because it is going to be very difficult for me to move forward unless I'm sure you've got attorneys that are.
They will have an attorney with them.
Why are you answering for them?
Yeah, no, I got this one. I got this.
Your Honor, we have talked about this.
What did I just say to you?
From the very first second, the tension in this courtroom feels like a powder keg waiting to blow. Watch closely, the judge already senses something's off, and what starts as a seemingly standard update quickly spirals into a battle of roles, representation, and courtroom decorum. What happens next will test not just the patience of the bench, but the very boundaries of professional conduct. Buckle in, because this isn't your average legal spat, this is a showdown between law, ego, and blurred ethical lines.
Alex Romero versus Eric Cassidy. Are they both? Okay, I do have Mr. Okay, because Mr. Cassidy's usually here, but he's not here. He's there in there. He's just trying to mess me up. All right, and I do have both the Jeromes. Got it. Okay.
Good afternoon, Your Honor. How are you? Gail.
I'm about to find out.
Gail Rosen appearing at Francie Novar appearing on behalf of the defendants.
Okay.
I'm Donna Toe. I was the attorney for the Jeromes. I am now a plaintiff. The Jeromes are here by Zoom, and we are in pro per.
Well, hold it. You're a plaintiff yourself?
Yes, they counterclaimed and.
Oh, okay. Gotcha.
It's complicated.
Well, not really. So,
if I could, Your Honor, just what were.
I just want to know who has been representing the Jeromes.
Did you catch that? The confusion around representation sets the tone for the entire proceeding. The judge is trying to establish clarity, who is actually advocating for whom, but already, the waters are muddy. This isn't just sloppy preparation. In a courtroom, clarity of roles is critical. Without it, everything becomes suspect, every statement, every motion, every filing. When attorneys start playing multiple roles, things can quickly slide from legal to unethical.
Representing themselves.
Is that correct?
That's correct.
Yes, Your Honor.
You're going to represent yourselves?
That was the idea.
Yeah, I'm not sure whose idea.
With that was the idea with Donna as our agent, because she managed everything for us. So yes, that's where we are.
Okay, but I just want to make sure you're going to represent yourselves in the legal proceeding.
We're representing ourselves today. I don't know. I mean, what I'm hearing from you is that perhaps that's ill-advisable. But yes, today we are here just representing ourselves.
Okay, no, I didn't mean to say either way, except that I just want to make sure I'm clear that from a legal standpoint, you guys are representing yourselves.
That's correct.
But you're doing it for today for sure. But
when a judge says, you're representing yourselves, for today, it's not just a procedural checkpoint. It's a warning flare. The implication? This case is far too messy to proceed without legal representation, and everyone knows it. For viewers wondering, yes, individuals can represent themselves in court. But when emotions run high and legal lines blur, that decision can come back to haunt you.
It may change.
Yes, sir. Yeah.
Got it. I got it. Okay, now.
So we're here on two motions, I believe, but before I get to those motions, if I can provide a brief update to the court.
Sure.
So I just wanted to let you know that, or the court know that in July, the tenants advised, as did I, advised the landlords that they would be vacating the property prior to September 1st, 2024, provided notification 2 months ago to give the plaintiffs an opportunity and significant time to find new tenants before the start of the academic year. So the tenants have found alternate housing and they will vacate on August 31st and return possession of the property to the landlord. I'll need to know where to leave the keys. And they'll continue to comply with the court's order to pay rent into escrow until the case is decided.
Okay.
So just as a, go ahead.
No, I was gonna say.
Just by way.
Here's where it gets interesting. The tenants have already decided to leave, but not before dropping a bombshell: claims of surveillance, false police reports, and constructive eviction. This isn't just a rental dispute anymore. These are serious allegations, and they're planting the seeds of a broader legal narrative: abuse of power, violation of tenant rights, and retaliation. Ask yourself, what would you do if your landlord stood on the road outside your house, watching?
The reasoning is that they contend that they've been constructively evicted, not only as a result of significant delay or failure to address a plethora of necessary repairs, but also due to substantial privacy violations and a violation and interference with their right to quiet enjoyment. Ms. Tope has routinely noted that she frequently conducts what she calls security checks at the property, as well as what she refers to as due diligence surveillance, watching the property from the road. So I'm not aware of anything that allows that to occur. Additionally, she's falsely filed
Surveillance, false police reports, and repeated court filings. These aren't just aggressive landlord tactics. If proven, they cross into civil harassment and possibly criminal behavior. The phrase constructive eviction isn't just legal jargon, it means a landlord made living conditions so intolerable, the tenant had no choice but to leave. In court, that changes everything. If the judge agrees, it could flip the case entirely.
a police report accusing the tenants of assault, filed a PPO making the same false allegations, and now filed a case in circuit court, similarly falsely accusing the tenants of assault and battery.
Excuse me. There's a new filing, or is
In
that?
circuit court, yes.
Okay, so when did that happen?
I'm not sure when that was filed.
It's a civil case.
Okay, I understand
And
that.
it has nothing to do with the landlord-tenant issues that are before this court.
We'll come back to that.
So the good news is that
There's going to be some. Go ahead.
since the tenants are vacating the property in about a week or 8 days, plaintiff's motion to enter the property unimpeded by the tenants and their dogs is moot. So they can enter the property after August 31st without any fear of interference from the tenants.
Okay.
So we just have our motion then to strike the plaintiff's report to the court on mediation. I believe.
Before we get into that,
Sure.
this is where this gets a little bit weird. Did either of the other parties have anything to say about the vacating the premises and the like? I guess the only people that wouldn't. Well, I'll hear from anybody.
Meet Miss Toe, the agent at the heart of the storm. Her insistence on speaking as the landlord's representative may seem routine, but as you'll see, this is no ordinary property manager. Her actions, filings, and voice in this courtroom will soon lead to a legal meltdown. Keep watching as the judge begins to peel back layers of representation, bias, and possible misconduct.
Ms. Tope.
I'm the agent who has managed the entire lease from the beginning to the end and had all interaction on the lease and its terms and meeting the responsibilities of the landlord as their agent. I did that. And as far as the request or the assertion that the plaintiffs were leaving the property September 1st, they have not requested nor gotten written permission to terminate the lease. And they have not,
See, this is.
Did you feel it? The judge's tone just shifted. When he says, "This is where this gets weird," it's not theatrical, it's legal frustration. He's realizing that Ms. Toe is blurring professional boundaries in real time. The line between agent, attorney, and party is about to get so tangled, it threatens the integrity of the entire hearing.
This is where this gets weird. Okay?
Okay,
Because I don't, as you stand here before me today,
yeah.
how are you asserting that on behalf of the Jeromes?
As the agent who has been completely involved in the entire performance of the lease from the standpoint of the tenants.
Okay, that's why, as I said before at the last hearing, that we actually were all here,
Yes,
this gets messy. Because that notion, certainly you can say up to a certain point that's occurred. However, it's really up to Jerome's to say that.
Okay.
well,
No, I mean, it is murky because, of course, as our agent, all these, from our perspective, all of these things are allegations we're not there on the ground to see.
Yeah, okay. And that's, let me just stop you there because I think
it seems to me that
it
these
would,
issues for trial as opposed to being.
what issues for trial? Well, here's what the
Their
issue for
count-
trial
This
was.
is one of the most crucial points in the entire case. The judge defines the real trial issue. Were the tenants constructively evicted? That question alone reframes the entire narrative. It means the legal battle ahead isn't about permission, it's about accountability. And when you're a landlord, that's a dangerous shift in power.
These are
Whether or not they were
issues-
constructively evicted, they're leaving. If you listen to what Ms. Wilson said, they're not seeking your acquiescence to leave. Their belief is that they've been
Let's break this down. The tenants aren't asking permission to leave, they're asserting they were forced out by unbearable conditions. That shifts the burden of proof. Suddenly, the plaintiffs aren't just landlords, they're defendants in a wrongful eviction claim. The stakes? Potential damages, reputational harm, and even sanctions.
constructively evicted from the premises.
Your Honor, if I may, my intention was to notify the court and provide an update on what's happening to date. They're leaving. The motion is therefore moot. And whether or not they've been constructively evicted will be determined by this court. We're not
Absolutely.
asking the
Right.
plaintiff's permission. They're leaving.
That's why I consider that to be an issue that needs to be decided down the road as opposed to how did the Jeromes feel about it? I think that they will assert themselves
Okay.
at that time.
Counsel, this is where our problem is. You can't you're holding way too many different roles. I don't know when you're talking to me, whether you're talking to me as an attorney in the case or as a party.
Listen to the judge's voice, it's firm, frustrated, and incredulous. Why? Because Ms. Toe has turned this courtroom into a legal labyrinth. Is she an agent? A former attorney? A plaintiff? When the same person wears too many hats, it becomes impossible to separate fact from advocacy. Judges hate this, and so should you. Because justice can't be served if roles aren't clear.
In the case. But it worries me because of this court's order,
Yes.
when you're talking about something, making a representation as to almost representing the Jeromes, because that's going to be a problem.
Okay, they have counterclaimed against the Jeromes and me And these are issues in their counter complaint that all of the
Okay.
things that I.
I didn't want to say this, but here's what I'm just going to say. Here's what the problem is, counsel, and why I did what I did. The problem is that, as Mr. Rome was saying, they weren't there. So let's assume, for the sake of argument, I'm not saying that it's the case, that you did something that was
If you've ever wondered how a simple housing dispute explodes into a full-blown legal crisis, this is it. The judge sees a problem. Ms. Toe is making legal representations that might later be disavowed by the very people she claims to represent. That's not just confusing, it's a breach of courtroom trust, and it's edging towards sanctionable conduct.
where all of a sudden they're liable for it and they didn't give you authorization to do it. And if that happens, you guys are on way opposite ends of that legal perspective and argument.
Wouldn't that be part of their counter complaint, which is
I'm not even getting to the counter complaint. I'm just you're standing here making representations on behalf of the Jeromes under the guise of being their agent.
Right, because I was.
However,
If I could just add to, Your Honor, the mediation, the report to the court, the mediation summary was also drafted and filed by Ms. Tope. The response to the motion was drafted and filed by Ms. Tope. So,
Here's where it heats up. A disqualified attorney continuing to act on behalf of former clients, under the guise of being an agent. Legally, that's a grenade. It undermines the disqualification order, blurs boundaries, and could expose her and her former clients to massive risk. If this isn't contempt, it's dancing on the edge.
what was the song?
Yeah. I hope it's inspirational.
so it's even murkier.
I wanted to put on a flannel shirt and go outside. Put on a hat. No, anyway, I'm sorry.
It's even murkier, Your Honor, in terms of where the representation begins and ends, and that's why we filed the motion to disqualify Ms. Tope as their attorneys, and you granted the motion to disqualify Ms. Tope.
So,
Your Honor, may I say on behalf of Mr. Eric Cassidy that we believe that Ms. Tope has completely violated your order. She continues to represent the Jeromes. By saying she's an agent does not mean that she's not doing legal work on behalf of the Jeromes. They admitted it themselves today. This needs to stop. She should be sanctioned, and we need to move forward with the trial in this matter.
And there it is, the moment this case tips into chaos. The defense openly calls for sanctions. Why? Because Ms. Toe allegedly violated a judge's disqualification order by continuing to file legal motions under the guise of being an agent. If true, this isn't just courtroom misbehavior, it's a potential ethical breach. Attorneys know this. Defying a judge's direct order can trigger disciplinary action, fines, or worse. And when the judge has to remind a former attorney where the line is, that's never good news.
the motion that is before you was a motion that I filed when I was the attorney. I no longer the attorney, but in your order, you said that we could pursue that motion, and you set it for a hearing today because you did not want to jeopardize the Jerome's rights. That is the motion that I put into notice for this hearing. And these other things sort of fall behind that. So I sort of am, I have been put into that position, this position, by filing that motion. And so I'm responding as the person who filed that motion, that you allowed us to continue to present before the court on this date.
Your Honor, that motion is moot. And
It's not moot because they haven't left. And
We'll be moot next week. And additionally, after the disqualification order was signed, Ms. Tope filed an amendment to that,
No, I know.
to that motion, and then a response to our motion to strike. So it continues, and there's quite a lack of clarity as to what.
What you're witnessing is rare. The court isn't just annoyed, it's alarmed. The judge now sees Ms. Toe as someone who's willfully misusing legal filings after disqualification. Worse, there's mounting evidence that she's acting like legal counsel while claiming she's not. That's what makes this moment so explosive. It's not about mistakes, it's about intent. Did she knowingly try to manipulate the court? That's what the judge is beginning to ask.
Ms. Tope's role is in this matter.
And Your Honor, I think it's willful at this point. She knows. She's been in this court and in front of you long enough to know that you told her not to do that. There's a clear conflict of interest between her and the Jeromes that will be apparent at trial. So she's not only having the conflict of interest, but she's a witness and she's participating as an attorney for herself, an attorney for the Jeromes still to this day by her last two pleadings.
the response to the letter was because I, as their agent, set up that dispute resolution settlement meeting. And so I feel I set it up with the University of Michigan because it's a term in the lease. And so I felt like.
But Your Honor, it was filed on their behalf after she was disqualified.
Oh, I know.
And it was also a completely improper filing. There's no, I don't know why a report was just submitted to the court on facts that the court wasn't seeking information about. It doesn't ask the court.
That's in our answer, my answer, because I'm the one that had it set up, and I'm the one that got affirmation from the director who set up the meeting that it was not mediation, it was not legal mediation, and the assertions that were put into their motion to strike were not accurate.
Your Honor, Ms. Tope wasn't at the mediation. That was the point. It was the plaintiff about Ms. Tope. She prepared their affidavit. She filed their affidavit. It is mediation. The court ordered mediation. This is all a type of mediation that was provided. The parties agreed to it. The parties signed a confidentiality agreement that applies to the entire process of the mediation.
And our answer answers that because he directly said, and let's not that it was not mediation and did not have any legal import, and that they would not file a report with the court.
They would not file a report with the court because it's confidential. They signed an agreement that said it's confidential. The court rules provide that it's confidential. The rules of evidence provide that it's confidential. And now you're trying to get that information in yet another time when the information is confidential and shouldn't be. In your Honor,
this is the emotional and legal crux. Confidentiality. The judge is furious because confidential mediation details were submitted as public court filings by someone who was no longer supposed to be participating. For legal viewers, this violates rules of evidence and the very foundation of mediated discussions. The breach could compromise the fairness of trial. The courtroom is now caught in a tug-of-war between ethics, confidentiality, and courtroom control.
We requested that it be withdrawn. Can I remind the court that Ms. Tope tried to get this information in last time at the hearing, and I objected as this was information to settlement discussions, and Your Honor said, yes, I'm not hearing any of this. So she turned around and put it in writing and submitted it. And MRE 408 does not say mediation. It just says settlement discussions cannot be before the court.
And the settlement discussion, nothing about this, Your Honor. Nothing about the settlement discussions was disclosed by the Jeromes. What was in their letter? They They described to you that they did discuss the issues of the landlord-tenant case that was presented to the
Okay,
dispute
folks.
resolution people, assistant. And it was Mr. Cassidy who went off the rails and talked about things that had nothing to do. No,
Object. She has
they,
no personal
they
knowledge.
drafted that letter.
So
It's their
why-
words in that letter.
So if I can renew my.
Can I just, hold on a second.
Certainly.
Ms. Tope,
Yes.
I don't like finding that attorneys are violating not only the written orders of the court, but certainly the spirit of the court's orders, and are trying to.
If you've ever wondered what it looks like when a judge reaches their limit, this is it. The moment he says, "You need to stop," it's not a suggestion. It's a warning, possibly the last one before real consequences hit. Judges are the gatekeepers of order and fairness. When they have to micromanage an attorney's every word, that's a crisis in credibility.
Go around that. And when this whole thing about the disqualification started, what I honestly thought was that, and I ultimately ordered and was waiting for, was a substitution of attorney, because I didn't want the Jeromes being without counsel.
And I have searched far and wide among all the landlord-tenant attorneys who have appeared before you, and nobody wants to take the skillet of snakes. I have an attorney who is not part of the landlord-tenant attorney group, but she has not been able to file an appearance for me because she was in court today.
Who, but is that for you?
Yeah, she will represent the Jeromes as well, but she's not able to.
Whoa. Okay. Stay with me here. Stay with me here. Stay with me here. I don't care who the attorney is.
Okay,
That attorney
cannot represent
can
the Jeromes. Andy.
represent both. There is.
The judge now drops a nuclear legal truth. The attorney Miss Toe wants to hire cannot represent both her and the Jeromes. Why? Because their interests are on a collision course. One may end up blaming the other in court. That's called a conflict of interest, and representing both sides is ethically prohibited. The court is now trying to protect not just justice, but everyone from each other.
Even from what minimally I know about this case, just from the plea, that can't happen. And
Okay.
I'm not going to allow that to happen.
Okay,
Because I think, quite honestly, and I didn't want to say it out loud, but I'll just say it out loud now. I think the interest of the Jeromes are going to, at some point, be absolutely in direct conflict to your own interest.
Understood.
okay. No, I value your advice, every word that you've
I don't
told
give
me.
advice. I give opinions and orders, but go ahead.
Okay,
Ms. Toe,
yes,
you need to just stop.
okay.
No, you need to stop doing what you're doing in this case. You can certainly defend yourself. I'm not entirely clear of the relationship that you have with the Jeromes, but I will just say that what is happening and what you're doing is potentially jeopardizing their positions in this case, as well as your own.
I hear what you're saying. I intellectually do not understand, because,
Just
I handled the
basic,
whole-
just basic.
okay,
If you did something
yes,
that they did not implicitly or explicitly give you permission to do,
right.
that then would, because you're acting as their agent and it causes liability to the Cassidys. You with me so far?
So far,
They come after you because they didn't give you authority to act.
they meaning,
The Jerome's.
oh, because they're going to go after.
Because now all of a
Jerome
sudden
because
they're
of something
like,
I did in
Pardon?
performing the lease. Because they are going after me for something I did in executing the terms of the lease that I signed.
but they're going after not only you, they're going after the Jerome's. And the Jerome's may have said, oh, she was supposed to do that,
Yeah,
right? And that the Jerome's, I'm going to presume, are going to say, we don't want liability for that. She didn't have authority to do that.
right.
And
This is the most dangerous moment yet for Miss Toe. The judge presents a likely future. The Jeromes might turn against her, saying she acted without their permission, and if the court agrees, liability falls on her. She may be facing a lawsuit of her own, filed by the very people she once claimed to represent. That's not just irony, that's potential professional ruin.
So it's on me.
yes, let's presume it comes out that way.
Yeah.
The problem is when you're representing them, that will never happen.
As the agent
No.
who
no.
signed the
As
lease.
as you're representing them and making the statement as though you are one in
Okay.
this court, that will never happen. The fact that that can't happen or won't happen is where there is jeopardy and prejudice to the Jeromes in terms of what their position might ultimately be.
Okay. The attorney that I have retained, if she represents the Jeromes and
won't.
I represent
It's
myself.
so weird.
No. I think,
It's
can I
weird
just
that
interject?
that you're retaining the attorney. That's
I
just so strange to me. I'm
Yes,
sorry.
no, we're,
Yes, go ahead.
okay.
This was the breaking point. After all the confusion, tension, and warnings, the judge finally hears what he's been waiting for. The Jeromes will get their own lawyer. This is not just a procedural step, it's a survival move. Because if they didn't make this choice, they risked sinking with Miss Toe's ship. But even now, it may be too little, too late.
You've made it abundantly clear that we will retain our own attorney. And
Wow, somebody actually is listening to me.
I really don't know what, well, I finally got it. And we'll have to proceed from there. As far as the things that are on the agenda today, I know that our contract does, I guess this is an anticipatory breach of the contract if they move out. But again, I would want to have a lawyer here to talk about that. I am understanding some of the language that's going back and forth between you and the attorneys for the Cassidys. But we're going to have to prepare ourselves to distance ourselves from Ms. Topin. So I'm comfortable with that. And I'm sorry it's taken us so long to get there. Alec, do you have anything to add to that?
No.
Watch how even in their most composed moment, the Jeromes seem lost. The brother barely says a word. The sister tries to regain control. But what they're really doing is scrambling to detach themselves from the legal storm Miss Toe created. This moment is raw, real, and reflective of how quickly courtroom alliances can crumble.
Okay.
He's a good husband.
Yes. No, he's a brother. He's
What'd
a
he say?
brother.
Your brother?
My
Yeah,
brother.
okay, then he's very good.
Yeah.
Like,
Yeah.
Good brother.
sister asked, do you have anything to add after I talked? No. All right.
He is. They are. They're great people. Okay.
Okay, so when speaking to the Jeromes, how long will it take you to get attorneys? Because it's going to be very difficult for me to move forward unless I'm sure you've got attorneys that are.
They will have an attorney within.
Why are you answering for them?
Yeah, no, I got
Because
this
we've
one. I
talked-
got this.
Your Honor, we have talked about this. We have talked
What
about
did I just say to you?
in the past.
Oh my gosh. Look.
Yeah, no, I just to interject again. Alec, it's the 23rd of August. I would say after I have 11-year-old, she's beginning school. Could we put it into the beginning of September? I would think that we should be able to find some.
Okay, let me ask you this. Could you guys have an attorney in, say, 2 to 3 weeks?
Yes.
She just
3
said,
weeks,
Or more.
please. Yes.
3 weeks? Is that going to be tight for you? I don't want it to be tight for you. I'm just,
Alec, what did you say?
I said 3 weeks. I would like the latter of that range if possible.
okay, so at least 3 weeks to get you. Okay, very good. See, I knew he'd say something eventually. So, okay, all right. So, all right.
So I do think, Your Honor, our motion to strike is pretty straightforward.
Yes, it is. Okay, so, and this is what I don't understand. Why do I have a report to me at all?
because in typical actual legal mediation, the mediator gives a report. And because it was my understanding from talking with the Jeromes after the session that I had arranged for them, things went much further than the subject of the meeting was supposed to be. And it was discussed with, go ahead.
Yeah, I just wanted to say that, when we talked and reported, Donna was still our attorney. Alec and I, in our ignorance, didn't know that. I guess we should have thought about it, but since it wasn't an official mediation, according to the agency who conducted it, there was an email that said that we didn't think there would be a violation, and didn't know that it. Again,
We didn't discuss terms of the tenant lease.
Okay.
What we discussed with Donna was issues that were beyond the discussion matter of the tenant lease agreement that we thought we were meeting with regards to the mediation activity.
Got it.
Your Honor, it all occurred during the mediation process, the confidential process. The report was filed after Ms. Tope was.
No, I get, certainly get that part.
Moreover, Judge, I've done hundreds of mediations or many more than that. And yes, reports do go to the court, but the substance of the discussions never go to the court, just that what happened as far as if they came to a resolution or not.
But even to the extent that they're relevant, that report comes from the mediator. I don't get this.
The judge sees through it all. Ms. Toe filed a report no one asked for, breached confidentiality, and then refused to withdraw it. That's not legal advocacy, it's personal vendetta disguised as process. This is the behavior judges cite when they issue sanctions. The only question left, how harsh will they be?
That's why when I saw it, and I was reluctant to even read it and just skimmed over it because I didn't ask for it. I mean, if it went to mediation, so the first thing that I did is I went to the leasing contract, basically, or wherever it was, to determine if, for whatever reason, as part of that provision, I was supposed to get it because I couldn't figure out why I was getting this. And that's not in there. And so I couldn't figure it out. Given all of that, does anyone have opposition to the court striking the response to the court?
Both, Your Honor, the affidavit as well as the response, which then recounts the response to our motion. When
everything. I'm talking everything because none of it should have been here. So I'll ask you, Jerome's. Do you guys have any?
We do not. Go ahead, please strike it. Thank you.
Okay. Miss Tope, because she's a party, I gotta ask. You have any, given what's been said, do you have any objection to their motion to
None.
strike?
None,
All right,
no.
then please prepare an order to that effect.
I would still ask for costs and attorney's fees, Your Honor. We had requested that this be withdrawn to avoid the necessity of filing this motion.
Ms. Tope,
Can you-
why didn't you withdraw it?
Sorry?
Why didn't, let me ask this, Ms. Rosen, who did you make your response to withdraw to?
My email to request that they withdraw?
My response to my withdrawal of the letter.
I sent it to all parties.
Okay,
So you sent it to the Jeromes also?
I sent it to the Jeromes and I sent it to Ms. Tope by email. I don't have a physical address for the Jeromes.
Gotcha. Okay, that's fine.
Yeah.
Okay, so why didn't? Okay, see, this is where it's gonna get hard. because
Okay.
I already know the answer to it.
okay.
Before you say to the Jeromes, is there a reason why you didn't withdraw the report to the court?
Is there a reason why we didn't withdraw the report to the court?
Right, why you didn't acquiesce to the request to withdraw?
We were not aware of the concerns
Yeah,
related
quite
to the
frankly,
court
yeah, we
filing.
weren't aware of.
Oh,
how
you
to-
both started talking. What were you saying to
Oh,
me?
sorry, Alec, you go. You'll probably have a better.
I just said we were not aware of their concerns related to the court filing and were not aware of the need to rescind.
Well, and
Yeah, I guess ignorance.
you
was-
had no idea as to the ramifications of that happening, did you?
Correct.
No.
Your Honor, can the court inquire of the Jeromes if they sought legal advice from Ms. Tope after we sent the email asking them to withdraw?
We didn't,
No.
we didn't seek legal advice.
Hold on, I understand the nature of why you may want that. I'm gonna have I'm very protective even as a judge as to what may be even parts of an attorney-client relationship and communication. So I'm not gonna permit that answer to that question. All right. Is there any reason you didn't acquiesce and just withdraw before?
I didn't acquiesce because I had set up the meeting. I knew what they were to discuss. I knew what the confidentiality agreement should have covered, not as an attorney, but as a person who was trying to effect that section 38 in our lease that allows for seeking advice from the University of Michigan. The mediation service allowed to students no longer exists, and they do not provide that service anymore. And I was referred to the dispute resolution where the parties talk about the issues under dispute, which are the lease terms. And so when there was discussion that there was no discussion with me about what was talked about or agreed to or anything about the lease.
I no longer know what you're talking about. I asked a very simple question.
I know. Why didn't I acquiesce? Because I felt as if there was a good reason to question the applying court rules to the settlement meeting that I had set up that was specifically stated by the person who organized it that it was not mediation. So I felt like there was a way to talk about what parts of it were covered and what parts.
Okay, but listen,
Yes,
if all the
which I did in an answer. I have an answer, but
if all
Your
the
Honor, I might concluded the mediation agreement that all parties signed, indicating pretty clearly that, or quite clearly, that it was confidential in two different spots.
Yes,
And-
but that
and-
confidentiality was over the subject matter of the meeting, and the subject matter of the meeting was strictly the lease and the lease terms. The things that they went off on had nothing to do with that.
The affidavit provided started out by stating during the mediation process this occurred. Mediation was still going on. If this was a conversation that the parties had in the parking lot after the mediation, it would be different,
Maybe.
perhaps.
There was no mediator present.
I don't, Mr. Tope, I really don't understand. First of all, why you felt it necessary to give that to the court, right? That's the first thing.
Okay,
But then once you made that decision to do it, and then counsel points out to you why it shouldn't have been done, is asking you just to voluntarily withdraw it, and you don't after looking at everything. That's the part I'm having a hard time with you not doing.
I understand your concern. I felt it was, since we had had such a long discussion about mediation and good faith, and we finally agreeing to try to effectuate the term in the lease and follow that, which is what I did, and the mediation aspect not being available, I felt that it was my responsibility to give you back what had happened during this discussion that you had made very clear that you would like to have us do. And so I did.
Why do you think I would need to know?
What?
Why do you think I would need to know?
I don't know, because you told us to do it.
Your Honor, clearly she's just trying to prejudice the
No.
defendant counter plaintiffs by providing false information to the court.
No.
She knew she wasn't supposed to.
No,
provide it.
no, strike it.
At the last hearing.
It's not going to make any difference. The judge will not make any decisions based on that report. It was just saying what happened. That's all. And I have no problem striking it. It's causing such problems.
Costs and attorney's fees, and we'll let the court decide how to proceed.
I've listened to you, and the reason I was asking the question is, Ms. Tope, tell me why I shouldn't sanction you.
Sanctions are now on the table. And it's not because of one mistake, it's the accumulation, defying orders, misrepresenting roles, leaking confidential info. The judge isn't just frustrated, he's considering punishment. This is what courtroom failure looks like when ego overtakes ethics.
Because one of the things that comes out in this back and forth is that I am being attributed by the other party because I am a plaintiff in the counter complaint as having ulterior motives. And honestly, I don't. I'm just trying to respond appropriately to my responsibilities as the agent who has been managing this lease from the very beginning. And
Ms. Tope, that's not a real answer to my question.
I know. Well, but that's how I'm thinking. I'm not doing anything willfully, intentionally, or in an aggressive, oppositional way towards their clients.
And it doesn't have to be aggressive. It's still in violation of the confidentiality agreement, the court rules, the evidentiary rules. And given an opportunity to withdraw it, you didn't. So here we are.
And that is part of the story, but the other part of the story is, given an opportunity to withdraw it, I did it because I felt I had a responsibility to report what the judge had ordered us to do.
Your Honor, I don't see.
So-
I don't know where that responsibility came from. If it came from a court rule, if it came from the rule of evidence.
It came from his discussion, just like this. I totally hear what the judge said.
I told you to do that?
Ms. Tobin
No.
is making things up right now. And it's improper, and she needs to stop doing that. She needs to stop making false statements to the court.
Okay. Anything else you want to say, Ms. Tim?
No, except I am not making false statements to the court, and I am trying to express my motivations. And you asked me why I didn't, and I tried to express why I didn't. You know,
Ms. Tope,
it's in your hands.
so here's what we're going to do. Place in the order that I'll take sanctions and costs under advisement.
Thank you.
And I'll decide whether I'm going to order them. And here's my reason. I typically don't, I realize there could be violations. I typically don't sanction attorneys if they've didn't sort of have ill will in doing what they did. And I understand one may look at that differently, right? But sometimes people do things just out of sheer ignorance.
If you don't sanction ignorance, I will plead it.
I don't think you have to plead it. I think we pretty much have. Thank you.
We'll go from there. Your Honor, I would ask just one last thing really quick.
See, I told you the minute Rosie started.
So
I'm
since
like, why can't you talk? No, go ahead.
Is no longer about possession. Possession will be returned. And it's going to be just about
Even as the judge offers mediation and a peaceful way forward, the scars are showing. This case is no longer about housing. It's about trust broken, power misused, and a legal system trying to clean up the wreckage. Everyone is walking on glass now. Because one more misstep could turn this civil dispute into a career-ending decision.
compensation damages. I woid ask if the court is so inclined and has the time, and once the Jeromes have attorneys, if you would be willing to engage in your incredible shuttle negotiations and allow us.
See, you've been talking to Mr. Fink too much, first of all. But
I've seen it in action, so.
yeah, I don't, and I really don't have a problem with that. And ultimately, if we could get the case to that point, I'm not going to have a problem with that once we get to the final settlement part and do that. But I've got to make sure that the Jeromes have attorneys in place and that their interests are protected, and we could do that. So, yes.
There's another procedural matter. Sorry.
No, it's okay.
So, after Ms. Tope served, one of her notices, she filed a complaint that wasn't timely. That was, I think, her third complaint she's filed in this case. So then she went ahead and filed a fourth complaint. In the meantime, we had responded.
Fourth complaint.
We had responded to the third complaint and counterclaim, but now we we have not yet actually officially answered the fourth complaint, and we needed an amended counter complaint. So I don't know if the court wants to give us a timeline for that. And there were two case numbers, so I think the court mentioned it, consolidating those cases.
Well, they're gonna, right. I mean, the district court doesn't have a great way of doing that. So how much time are you gonna need? Okay, so here's gonna be part of the problem. Part of the problem is you're going to be filing an answer and a counter complaint, which is going to include the Jeromes, which are then going to have new counsel swing in, right? So I think I'm going to do it this way. I'm at this, and that was filed by Ms. Tope on behalf of the Jeromes,
Yes,
the fourth one.
the complaint, yes.
Okay. And do a separate order. I'm not going to require an answer to that at this time. Because I don't know, once the Jeromes get counsel, I don't know what they might want out of that part complete. I mean, I don't know what their position was.
Those were filed not by me as an attorney. They were filed by me as the agent for the Jeromes. I was
Okay, look.
their attorney till later.
You got to stop that. I mean, you really do. You can't like split yourself and say, I'm doing this because I'm doing this as whatever, but now I'm acting as, you can't do that. Because you're doing it, when you do it, you're doing it to justify you doing something, which quite frankly, I would agree with counsel probably is in violation, certainly if not directly, the spirit of the order regarding your disqualification. So
Right.
you just need to stop it.
So I, Donna Tope, am not able to respond to anything that had to do with my operating as their agent before I became their attorney.
Hang on a second. I don't know how to answer that. Because what may end up happening is the Jeromes get an attorney,
Yep.
the attorney says, oh, heck no, she's not doing anything on your behalf. And they follow that, then you do nothing. Your agency at that point certainly ends.
Mhm.
All right. So I almost hate going here, but I'm going to. So Snowbird, you're going to prepare the order regarding no answer required until the court directs otherwise.
Yes, Your Honor.
Okay,
Is
fantastic.
there also a deadline for a counterclaim though? Because we filed a counterclaim in the third amendment, but the claims are going to be, we'll be adding claims for sure.
Answer and counterclaim. Just everything's on hold because it's not you delaying it. It's not the court delaying it. I just have to it's the court delaying it because I have to give the Jerome's time to do what needs to be done. All right. Now, without raising a new issue, what is the circuit court case?
I filed I called the sheriff and filed a report of an assault and battery at the property by Eric Cassidy and Paula Cassidy, and followed up with that with a civil complaint of assault and battery.
When did this allegedly happen?
In the early spring. I don't have any of that information with me. It's not pertinent here.
Around March 8th, I believe.
March 8th.
And it was during the process of her, she claims the event occurred during the process of her serving a notice on the property.
The notice to quit.
Yes, at that point, it was to allegedly people that weren't supposed to be living in the house that were living there. It wasn't true. And then I guess, Your Honor, the question will become, that did occur during, I think it's a permissive joinder sure, I don't think it's a mandatory joinder, but it's a permissive joinder. So one question will become, will we be removing our case to circuit court and then join that as well?
Okay, so this is it's like Groundhog Day. If you remember the first time that you were here, and we were going around and around about that, and I said I could do something that I really don't want to do, and that is get appointed a circuit court judge and just deal with it. And I just let you know what I'm thinking. Excuse me for the pause, and that is, I don't think you should be taking up Judge Connor's time with something that is a result of a landlord-tenant case that I have. If it's regarding the serving of a notice, outside of the landlord-tenant, why would you and the Cassidys even be in contact with each other?
I wasn't in contact with them. I was outside.
Okay.
So, Your Honor.
Your entire relationship with the Cassidys is a result.
The judge's voice drips with suspicion. It's almost like you're trying to harass them. That line doesn't come lightly. It's a serious accusation, one that implies legal abuse. Filing a separate civil case that could have been handled here? That's not just overkill, it might be abuse of process. The court is done playing games.
Comes from this landlord-tenant relationship. Right? That was a question.
Yeah, no, yeah, absolutely. I mean, the only reason I was there was in my agency capacity enforcing the lease.
Exactly. So why do I have a separate court hearing an action that came from that? Let me just say this. When was this filed?
Oh, August 8th.
Of this year?
Yeah.
You know, so I'm just going to tell you, and I don't know anything about it, but this is a lot like her. It's almost like you're just wanting to harass them.
Oh my gosh.
Why? Then answer me this.
Why would I do it? Because.
Why wouldn't you file it if you felt that there was an assault and battery? Why wouldn't you file it in this case?
I didn't consider it a landlord-tenant case.
Civil actions up to 25,000
Mhm.
are the jurisdiction of the district court.
Yeah, I asked for over 25,000.
Ask for what?
Over 25,000.
Of course, everybody does. So then why wouldn't we have just done it? And then we might have been back in that whole discussion about, does it get removed? Does it do whatever? I mean, I think I can't help but think while all of this is going on, and quite frankly, you're not getting your way on a lot of things because some of it I don't understand. No, you don't. Listen.
Yeah, I'm listening.
That what you did is you took that case and almost as an abusive process, filed an action in circuit court to harass the Cassidy. That's what it looks like. So here's what I'm going to do, because I don't think they should be trying to answer.
I will withdraw it.
No, you do what you want to do, because I'm just going to call Judge Connors in the circuit court, and with his permission, I'm going to take it, because there's no reason he should be handling it. All the issues, God help me, but all the issues are here.
It was an assault against me personally. It has created a hostile work environment. I am afraid to do my job.
This is worse than like being civil. Either we're talking about you personally, we're talking about you as an agent, or we're talking about you as an attorney. You got to make up your mind.
And Your Honor,
all of these issues are what led to the tenants to vacate. I realize that if they can tell us where to leave the keys, I will Mr. Cassidy's on the call. I'll know where to leave the keys.
Mr. and Mrs. Jerome, where should they leave the keys?
It's brothers and sisters.
Mr. Okay.
Ideas?
Yeah,
I don't know.
said-
I'd have to think about that. I
Yeah.
don't know. This is such I'm so disoriented by this whole thing. So I have to get back to you.
Is there a lock? I thought there was a lock box on the back door that we could place them in.
Is there?
Yes.
Okay.
Perfect. That works.
It's easier. They can be brought to my office. I did want to make just a clarification for the record. She filed her complaint on July 18th. July 12th, this court heard argument to disqualify and order disqualification. And then 6 days later, she filed it.
Hey,
I withdrew.
I knew you would.
I withdrew within 7 days.
You withdrew what?
I withdrew as attorney on this case.
You really didn't. But that's okay. You were disqualified. And for very good reason. And I did it. And everybody can be mad, but I did it. So here's what we're gonna do. Where do you is there a lockbox back there?
Yes, there is on the back door.
Mr. Cassidy, do you know if there's
Hello, excuse me, Your Honor. There is a lockbox. It actually has keys, and it's on the door. I don't know the code for it. We can simply leave the keys in the kitchen, and they have the lockbox keys that they can enter the house. Or we can.
do you have a problem with that, Mr. If
No, that sounds great.
Okay, just leave them in the kitchen.
Okay.
All right. Just take a picture that you left them, so I don't have to deal with whether or not the keys are there. What?
Yes.
Do we have a date to return?
Yeah, I really don't want to give one, but I will. She said with a smile. You have a date to return? All right. Let's do it this way. They needed at least 3 weeks out. He was looking at, why don't we get 4? Why don't we make it September 20th? Will that work for you?
Fine, Your
Yes, Your
Your Honor,
Honor.
I've scheduled a mediation in the afternoon on that day.
And this would go in the afternoon. So what about the 27th?
I believe I'm available as well.
Would you be available the 27th?
Of September?
Yes.
Yes.
All right. And I won't say Mr. and Mrs. Will the Jeromes be available on the
Yes.
27th?
We will make ourselves available.
Okay, that gives you a little bit more time than the 3 weeks, but
Great.
Clock again, Your Honor?
well, I don't know. I set it at 9 and then my staff will send you notifications of the time. All right. Thank you.
Thank you. Your Honor.
Once I get there, I am.
This case started with a lease, but ends as a legal circus. Sanctions. Conflicts. Disqualifications. What should have been a property dispute spiraled into professional meltdown. And through it all, one voice kept crossing the line until the judge had no choice but to strike filings, consider sanctions, and possibly take over the circuit court case. What do you think? Was Ms. Toe acting out of duty or ego? Smash that like button if this courtroom drama stunned you like it did us. Drop your verdict in the comments below, and subscribe for more real-life breakdowns of the justice system's most jaw-dropping moments.